Welcome back to the deep dive. We're continuing our journey through the MPEP, the Manual of Patent Examining Procedure. We're still in Chapter 200, which, as you know, covers application types, status, benefit claims, all that foundational stuff. And today, we're zeroing in on a really critical section, MPEP Section 213. This one's all about the right of priority of a foreign application. Honestly, if you're dealing with patents across borders, this is, well, it's essential.
Absolutely essential. Couldn't agree more. Our goal today, really, is to help you understand how a U.S. patent application can essentially claim the filing date of an earlier foreign application. Think of it like a time machine for your priority rights. It's that powerful.
A time machine, I like that. And the stakes are incredibly high. Use that classic example we often talk about. Imagine an inventor files first in, say, Germany.
Okay.
Then maybe 11 months later, they file in the U.S. If they follow the rules in Section 213 correctly, that U.S. application gets treated as if it was filed back on the German date.
Exactly. But here's the flip side, and it's crucial. If they mess up that claim, if they miss a deadline, get the paperwork wrong.
Catastrophe.
Complete catastrophe. That 11-month gap. Suddenly, it's wide open. Anything published anywhere in the world during that time becomes prior art against the U.S. application. Even their own work could become prior art against them. It could absolutely sink the U.S. patent.
Wow. Okay, so clearly, getting this right matters. Let's dive into the rules.
Right. So this ability to claim priority, it's not just, a nice-to-have courtesy. It's formally established in U.S. law. We're talking specific statutes like 35 U.S.C. 119 and rules like 37 CFR 1.55. But instead of just listing numbers, let's focus on the core requirements, what really needs to be true.
Okay, yeah, let's break it down. Forget the code sections for a second. What are the absolute must-haves? Like, where does the first application have to be from, and who needs to be involved?
Good questions. The first big one is reciprocity, the country where that first foreign application was filed. It must offer similar priority rights back to U.S. applicants. It's about fairness, a two-way street.
Ah, okay. Like international agreements.
Precisely. This is usually guaranteed through big treaties like the Paris Convention or, more recently, WTO agreements. If the country isn't part of a recognized system that guarantees reciprocity, then generally you just can't claim priority from it. Simple as that. The second pillar concerns the inventors. We call it the common inventor rule. Basically, the U.S. application and that earlier foreign application, they need to share at least one inventor in common.
Makes sense. So you can't just buy someone else's early filing date.
Exactly. It stops people from trading priority dates that aren't linked to the same actual invention, the same inventive activity, has to stem from the same source.
Okay. Reciprocity and common inventor.
Yep.
Got it. Now, the part that probably trips people up the most, the timing. The clock is always ticking in patent law, isn't it? What's the hard deadline here?
It is indeed unforgiving. The standard deadline for most applications, think utility patents, plant patents, is 12 months. You have exactly 1 year from the foreign filing date to get your corresponding U.S. application filed.
12 months. Why 12? Is there a reason for that specific number?
Yeah, it goes back to the Paris Convention, actually. It was seen as a reasonable time frame, sort of an international standard to give inventors time to figure out their global strategy, maybe secure funding, translate documents, all the practical stuff involved in filing internationally.
Right, okay. But wait, I remember reading something about designs being different. Is that covered here too? Because that sounds like a potential pitfall.
It is, and yes, it's a critical distinction right here in the rules. For design applications, things focused on ornamental appearance. The relevant law, 35 U.S.C. 172, sets a much shorter window, only 6 months.
6 months? Wow, half the time. Why the difference?
Well, the thinking, historically at least, is that designs, being visual, tend to get out into the public sphere faster. Think fashion, product shapes. They're often shown or sold quickly. So the law demands quicker action to claim priority for them.
Okay, so 12 months for utility and plant, but only 6 for design. Miss either of those deadlines.
And the priority claim is gone instantly. No second chances on the filing date itself. So hitting that 12-month or 6-month deadline is just step one. You filed on time, great. But now you have to formally tell the USPTO you're claiming priority and prove it. This is done primarily through the application data sheet, or ADS.
The ADS,
Yeah.
right. So if the deadline is the rule, the ADS is like the official form you fill out to claim it. What specific information has to be on that ADS? What are the non-negotiables?
You need 3 key pieces of information about that foreign application. the application number, the exact filing date, day, month, year, and the country or the specific IP office where it was filed.
And accuracy here is crucial, I assume. No typos.
Oh, absolutely critical. A typo in the number or date, the examiner might not be able to verify the priority claim. They could reject it.
Yeah.
And then you're scrambling to fix it, potentially paying fees, wasting time. It's best to get it perfect the first time.
Okay, ADS filed correctly with the number, date, country. What else? You mentioned proof. That sounds like more paperwork.
It does, yes. You need to provide a certified copy of that original foreign application.
Ah, the certified copy. I've heard practitioners say getting that can sometimes be a real headache, depending on the foreign patent office.
It certainly can be. It's basically an official copy, stamped or sealed by the Foreign Patent Office, confirming that the document is authentic and was filed on that specific date. It's the USPTO's ultimate proof. Now, alongside the certified copy, there's the question of language. Let's go back to our German example. The original application is in German. Do you always need to provide an English translation right away?
Good question, because translations cost money and take time. So when does the USPTO actually require that English translation? Is it automatic?
Not automatic, no. The Rule 37 CFR 1.55i lays out specific situations. You generally only need to file an English translation if one of three things happens.
Okay, what are the triggers?
First, if your U.S. application gets pulled into a conflict, like an interference or a derivation proceeding, basically if you're fighting with someone else over who invented it first.
All right, makes sense. You'd need the details then.
Second, if you need to use that foreign filing date to overcome prior art cited by the examiner. You know, if the examiner finds something published after your German filing but before your U.S. filing, you'd use the translated German document to prove you invented it before that reference.
Okay, and the third?
Third is simply if the examiner specifically requires it. Maybe something's unclear, or they need it for a thorough examination, but it's not needed up front in most cases. Oh, and importantly, when you do submit a translation, you also have to include a statement certifying that it's accurate.
Got it. So translation is conditional, based on specific needs during prosecution or conflict. This all sounds very, very strict. Deadlines are hard stops. Paperwork needs to be precise. Is there any wiggle room? What if, say, the U.S. application was filed on time within the 12 months, but the ADS claim or the certified copy gets submitted late? Is there any hope? This is where it gets interesting, right?
There is some flexibility, but it's definitely not something to rely on. It's more of a safety net for genuine mistakes. If you miss the deadline for submitting the claim itself on the ADS or for filing the certified copy, you can file a petition.
A petition to the director, okay? What do you need to show in that petition? Is it just a matter of paying a fee?
Well, paying a fee is definitely part of it, yes, under 37 CFR 1.180G. But the crucial part is establishing that the lateness in filing the claim or the copy was unintentional.
Unintentional. How high is that bar?
It requires a convincing explanation and often documentation showing it wasn't deliberate neglect. It's not automatic approval. The USPTO reviews it. So while the option exists, the best practice is always treat the deadlines for the claim and the copy as firm. You generally need to get them in while the application is still pending, unless you're filing that petition for unintentional delay.
Okay, so a petition is possible, but not guaranteed, and requires proving the delay was unintentional. Good to know there's something. Now, we've mostly talked about standard patents. Does this priority right apply to other kinds of foreign IP filings?
Yes, it does. The system tries to be accommodating to different international practices. Two other types are specifically mentioned. First, inventor certificates. These were used in some countries, particularly in the past, as an alternative to patents. If you have one of those, it can potentially serve as a basis for priority.
Interesting. And the second?
Second is applications for plant breeders' rights. If you filed for plant protection in a WTO member country or a UPOV member country, that filing can also be used to claim priority for a corresponding U.S. plant patent application under the same time limits.
So it covers patents, inventor certificates, and plant breeders' rights. That's quite broad.
It aims to be, yes.
Finally, let's connect this to the big international systems. How do things like the PCT or the Hague Agreement fit into this picture of claiming foreign priority in the U.S.?
They're hugely important tools for managing this process globally. Take the Patent Cooperation Treaty, the PCT. Filing a PCT application doesn't grant you a patent directly, but it acts like a placeholder.
Oh, placeholder.
Yeah. If you file a PCT application within that 12-month priority window, claiming priority from your initial German filing, for example. That PCT application effectively reserves your right to enter the national phase later in potentially, 150 plus countries. It preserves that German priority date for all those designated countries, including the U.S., when you eventually enter the U.S. national stage.
So the PCT buys you time and simplifies managing that 12-month deadline across many countries.
Exactly. And the Hague Agreement does something similar for international design registrations. It streamlines the process. These treaties and the U.S. laws that implement them, like 35 U.S.C. 365 and 386, work together with Section 213. They don't change the fundamental priority rules, but they provide mechanisms to manage them much more efficiently on a global scale. Hashtag tag outro.
Okay, let's wrap this up. So for you, the listener, what's the bottom line here? Section 213, the right of priority. It's incredibly valuable. It lets you secure that earlier foreign filing date for your U.S. application, potentially shielding you from prior art that emerged in the meantime.
Huge benefit.
But it demands absolute discipline. You've got that strict clock, 12 months for utility plant, only 6 months for designs. And you have to nail the paperwork, the ADS claim with the right details, getting that certified copy submitted.
Spot on. And maybe tying this all together, this whole system is built on the idea of international cooperation, right? Reciprocity, mutual recognition, which leads to kind of an interesting thought to leave you with.
Oh, yeah.
Think about all these detailed administrative hoops you have to jump through. The ADS requirements, the certified copies, sometimes translations, the petitions for unintentional delay, the strict deadlines. Does all of this administrative effort designed to ensure fairness and certainty ultimately make global innovation easier by standardizing things? Or does the sheer weight of the compliance burden sometimes get in the way of that goal?
That's a great point. Is the administrative cost of certainty worth it, or does it sometimes stifle the cross-border protection it's meant to encourage? Something definitely worth thinking about.
Exactly. It's a balancing act.
Indeed. Well, that's all the time we have for this deep dive into MPP Section 213. We'd like to extend a special thank you to Mike Shepard, the creative director who organized this entire audio series. His efforts ensure that each section of the MPEP is presented in a way that is both accessible and engaging for learners and practitioners alike. Disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It is provided for general educational and informational purposes only and is not legal advice or a substitute for formal instruction. For authoritative guidance, consult the official MPEP, a qualified instructor, or a registered patent practitioner.